71.
Well, on Louisiana, in Ramos, on the jury trial right, the question of whether he had a right to a unanimous jury, there were Louisiana and Oregon precedents going way back that allowed non-unanimous juries. And we flatly rejected that historical example for the exact reason that Justice Alito and Justice Gorsuch have been mentioning. Those were rooted in racial prejudice designed to prevent black jurors from having their votes counted on juries in the wake of a decision like Schroeder in 1880. And we just said, no, that's inadmissible to account for that as somehow justifying an exception to the constitutional right. It seems like the same kind of thing here. What's different?
Justice Kavanaugh, we just disagree with the idea that that applies to this particular law from Louisiana 1865. But regardless, our tradition goes way back before that. New Jersey in 1771, 1721 Pennsylvania, the law said, quote, "You cannot carry any gun or hunt on the improved or enclosed lands of any plantation." The 1763 New York law, which the Solicitor General only read part of, says that it was unlawful to carry, shoot, or discharge any musket or other firearm whatsoever into any orchard, garden, or other enclosed land whatsoever. And there's other statute after statute. There's no allegation by anyone that those were motivated by any sort of racist concerns or the like. And what they've said is, oh no, that was just limited to poaching. That's just wrong. There's two parts, for example, to the New Jersey law. Part two is about poaching.
And
Part
on
one
those laws, a couple of them that you cite, it seems to me you're approaching the whole analysis upside down from how the court's cases have approached it. The court's cases have started with the text, which declares an individual right. And then in Heller and in Bruin, the court has elaborated on it. Of course, there's, as there are with all rights, as Heller said, some exceptions. But those exceptions, to be recognized, must be historically rooted. Deep tradition, a broad tradition, widely recognized, commonly recognized, not isolated examples, particularly not ones from the black codes, but even apart from that, not isolated examples. And I just don't see the kind of broad tradition of the regulation here that you see with the other things specified in Heller, for example.
So I agree with some of what you're saying. So I completely agree that the relevant test under Bruin is text, and then the next words you used were as informed by history. And so the question is whether or not there is some sort of right at the framing, whether the right to keep and bear arms was understood the right to assume an owner's consent to bring arms. That's where we think this case, their case falls apart, because for the first time, you'd be saying, if you accept their invitation, in the absence of any affirmative evidence whatsoever, a commentator, a court, anything that said that there was a right to imply consent, there's just nothing. There is precious zero on that. And here's why it's so important. You heard my friend when he stood up, he said, and under questioning from Justice Barrett, hey, is your rule going to apply to private homes? Because lots of states even today have those, Alaska, in Arkansas and the like. And he ultimately said, yeah, because the burden shifting, you wouldn't be able to defend the law under the burden shifting of step 2 of Bruin, in which you have to have demonstrated historical analogs and the like. That gets everything undone entirely. I mean, this court has a general rule. Justice Alito wrote about it in Kennedy versus Louisiana, which is when you are coming in to challenge a state law, you bear a heavy presumption that your challenge is invalid, that there's a presumption of good faith and presumption of regularity on the part of the legislature. If you just jump to Bruin step 2 and say, oh, this law deals with guns, therefore the burden flips to the government, then yeah, you're going to have a really difficult time defending laws. Every state is like the ones that deal with gun consent on private homes.
Well, which is why you don't want to get to